your views are. I know at Perkins, our AI group spans a lot of practice groups, from the technology and transactions group to the privacy and security group to IP, to content moderation to trust and safety, et cetera. And so I would imagine that AI is affecting all sorts and parts of your company and stakeholders. My first question is, how is your organization tackling the myriad of issues, opportunities, and challenges presented by AI? Is it more of a sort of centralized top-down approach? Or is it organized around product lines? Is it more of a cross-functional task force? And what are some of the key constituencies and stakeholders? And how are you sort of balancing probably differing points of view? I'll start with Dawn.
Sure. My answer is all of the above. Given, how new and fast growing this technology is, like you said, Meeka, we see applications and potential uses in the hundreds, if not thousands, and probably across every single department. Any department that creates anything or uses like a language in, language out type of business is going to be able to use AI. So that's anything from our legal department, our research department, our ad sales department, all the way through to probably having applications for production and development of content. So because of that, we're looking, we've sort of tackled it in a couple ways. I'll be honest, I think it came up faster than, the speed in which it became a reality was probably faster than we thought it was going to be. Right now, we have a cross-departmental task force, which I sit on, that is across every department in the company, and we have one key executive from every department. But then we're also going to have deep dive committees within departments, because they're going to have to get more specific than what we can tackle, across department wide. And then we're also in the legal department considering, whether we need some sort of corporate AI policy. We know a lot of companies have already adopted them. We're looking into it right now again, and everything is just sort of at play. The only other thing I'd say is I think the most important thing for us and many companies to think about right now is putting processes and awareness in place so that the right people, including the legal department, can know when AI is being used, both by our employees internally, as well as by vendors externally. Because if we don't know that it's even being incorporated, we're not going to be able to vet the right issues. So that's sort of like the number one thing that we're working on right now.
Thanks, Dawn. Super interesting to hear about how you're tackling, we're trying to tackle the issues. Jay Scott, you're more from a technology company, and I thought maybe your company might be tackling it slightly differently. So would love to hear your thoughts.
Actually, we're not. I mean, I'm going to just talk about the use of it as a tool for our company, right? As opposed to creating a tool for others to use. I think very much what Dawn was saying is how you have to approach it, because there are so very many places where AI can show up. It can show up HR, it can show up in data analytics, it can show up in creative works for advertising or commercials or creative things that you might create. So we put together a corporate-wide guideline, because this is just like anything that is, there are so many tools that are commercially available now in the nascent stages, but all it takes is a credit card and a couple of type keystrokes to get an account. And so we've created guidelines, just like we have for domain names and other things, that they have to be, if you find something you find is interesting, it has to go through a process to ensure that it is a tool that Adobe is willing to let into its systems, and something that we would be able, we know what the risks are we willing to accept those risks if there are risks identified with a certain type. But it's making sure that that's known company-wide, and it's a company-wide process. It's really not that different from all software that you take on board, and people have access to a computer that allows them to try to bring this into your system. So it's just having a coordinated effort, but making sure that your corporate comms team and your senior staff is making sure that that is getting, laddered down through the organization, and that it's a top-down directive, that it's not legal pushing this, it's the company's idea that it is the best practice in this area and having those guidelines available and clearly communicated to the workforce.
Thanks, Jay Scott. So let's do a deeper dive on and zone in a little bit more on generative AI, which is a subset of the larger topic AI. And I asked ChatGPT 3.5 yesterday to provide a definition of generative AI. And it defines it as being a field of artificial intelligence that involves training models to generate original and realistic content. These models learn patterns and structures from large data sets and then use the knowledge to produce new outputs. So to simplify, when I think about generative AI, I kind of break it out into 4 subparts, I guess. One is the input. What are the trained data sets that were used to create the output? 2, what are the prompts that were entered by whoever the user is? 3, the algorithms and other sort of secret sauce within the AI tool that helps process that data. And then finally, the output itself is generated by AI. And each of these sort of steps within AI generate different IP issues and legal issues. But we already see generation AI producing a number of lawsuits, a number of them class action lawsuits. So I talked earlier about the ones against OpenAI and Meta. But earlier this year, there were also class action lawsuits filed against Stability AI, Midjourney, and DeviantArt, who are all developers of 3 image generation tools, Stable Diffusion, Midjourney, and DreamUp. The lawsuit alleges copyright infringement, among other claims, saying that these are basically complex collage tools that on the input side, scrape data that belong to other people without their authorization, and then on the output side, facilitate the creation of what they deem as being unauthorized derivative works. So I thought I would turn to you, Jay Scott, to get your thoughts on, in light of these generative AI lawsuits, how are you assessing the infringement risk associated with, in your case, building AI tools, and in other cases, for users of those tools? And what are your thoughts on the infringement risks presented by data scraping copyrighted works? Is the data scraping potentially not copyright infringement because you're just taking ideas as opposed to expressions of those ideas? How about prompts like "in the style of so-and-so"? Are those somehow either right of publicity or copyright infringement uses that copyright law might have something to say about? So I thought I would start with you, Scott, to get your thoughts on.
Sure. Well, we looked at it very closely, and it is an unanswered question. I mean, when you look at it, when you understand the technology, the training seems to be a traditional fair use, that you are taking a copy of something that might be alleged to be an infringement, but because what you're taking is not either copyrightable or you're creating something that's completely transformative and doesn't compete in the market with the input, it's a fair use. But that question is not been answered by the courts yet. And it's a case-by-case analysis, and it's very interesting. So at Adobe, we took a long look at it and decided, well, we've been using AI, but it changes when it becomes generative AI. When you create something that is arguably competitive with the input. And so we thought about it for a long time, and we decided to use and train our AI, at least initially, it's being trained on licensed content that we have through our stock photography business. And so that has handled a lot of the issues for us. Now, we are thinking of adding to that openly licensed content like Creative Commons, zero licensed content, and content where the copyright has expired, things that were created before 1927. But that hasn't been done yet. But we've been thinking about it because it takes large amounts of data to make sure not only that you are producing quality work, but you also are getting out some of the biases that might occur because you have a limited amount of data. So that's sort of where we headed down that, and it solved a lot of the problems because we moderate our stock content looking for trademarks, looking for model releases, so a lot of the issues you would get from scraping data, we decided to avoid by using licensed data that has the necessary rights involved, because we didn't want our users to get in this quagmire of, is it fair use? Is it not fair use? And so we took a very hard look at that and decided. But when you take a traditional fair use analysis, I think, similar to the Google Books case that came out of the Second Circuit, you're going to find that this falls more in line with the transformative use that is fair use. But that is yet to be decided. And so as long as it's up in the air, we, at least at this stage, we're sticking with licensed content.
And music to a content owner's ears. But I do think it's interesting to think about it from the user standpoint. So Randy, I thought I would turn to you as a potential user of these AI tools. To what extent do you think about whether the tool provider is using licensed content, not licensed content?
Yeah, so
and all the risks involved with infringement.
Yeah, so the perspective I would, as business stakeholders would come to me, I would really want to understand what data that, they're looking to put into these tools and understand, is it sensitive, is it confidential, and, then is it getting commingled with other, third-party content or with the vendor content as the machine is learning? And then what does that mean, the end output, and who owns, which piece of it, and how are we going to know that in order to exploit it for whatever uses the business stakeholder is looking to do with it. So it's really working with the business to understand what they're looking to get out of this, as well as, what are you putting into this, and how do we protect best for it? So that's how I would probably think about it.
Yeah, so all sort of changing and evolving as we speak. So I thought I would talk about another sort of IP issue relating to generative AI. We talked a little bit about the input side, but there is the issue about the output side. And there's some information and some precedent around protectability of AI generated content. So the Copyright Office, for example, has rejected copyrightability for a registration by an AI, where in that case, it was a painting and the registrant was trying to have the author be the AI itself. And the Copyright Office said, no, he has to be human in order to be an author of the copyrighted work. But then there was another case where somebody put in for a graphic novel, and they actually allowed for registration of the overall book because of the selection, coordination, and arrangement of all the elements, the creative elements within the book. But they denied registration for the AI-generated images within the book. The applicant argued, I put a lot of creative prompts into it. I guided the AI. I decided which input was going to be used. The Copyright Office felt, at least in that circumstance, there was not enough human creativity to justify copyright registration. But I think there is a little bit of a sliding scale there. And the Copyright Office actually has issued a policy statement and a call for comments about this issue. It's also come up in patent law, and under the U.S. Patent Act, you do have to be a human to be an inventor. But again, there are issues around, if you use machines that facilitate some of that output, it's certainly possible that some of it will be protected either under copyright or patent law. So I thought I would turn it to first to Dawn, just to think about on the protectability side, what sort of things do you think about when your clients are coming to you and thinking about using an AI tool to create something? What do you think about on the protectability side?
Yeah, I mean, I think you articulated a lot of them, right? I think that if we are looking to protect something on the output side, right now, I would encourage my business partners to make sure that there is a lot of human manipulation, interaction, creativity that is applied to that output. Because I do think right now, like you said, it is a unsettled area of the law as to whether just the output from the machine generated can be protected by copyright. So, one of the our head of global technology likes to say, think of AI not as the pilot, but as the co-pilot. And I think that that's a really good way for us to think about it. And then, in terms of the output itself, whether that would be infringing, I think we've got to look at, whether our copyright law as it exists today is sufficient to sort of adjudicate whether something is or isn't infringing of an existing copyrighted work. I think there's certain areas to me that I think, yes, we can use the current copyright law, like a visual or audio visual work. You know, we already have those, a body of case law that sort of helps us analyze between the two, the existing and the new work, as to whether or not it's substantially similar. So I'm not sure if anything has to change on that level. But in terms of the other risks, you know, I would also be looking at a little bit what Randi said. It's not just about copyright, but we've got to look about issues of rights of privacy and publicity. I'd worry about data privacy. I worry about regulatory issues. I think the EU is already looking into the EU AI Act. I know our government is a little slow on some of this stuff, like with privacy, so it'll probably be behind, but eventually there probably will be laws in that area as well as guild issues and contractual issues that would come up.
Yeah, so it's not just about IP or protectability. There are a lot of issues and a lot of stakeholders involved with any piece of content that a media company comes out.
Yes,
very much as a
like an onion, many
Yes.
layers that we're going to have to, you know,
Yeah.
work through.
Very much a collaborative exercise, and so there's a lot of sort of hands in that. Jason, I thought I would turn it to you both to talk about both the protectability, I guess, of output, as well as some of the stuff that you started to talk about earlier around the infringement risks associated with output and fair use, whether it's transformative or unauthorized derivative work.
Well, at Adobe, we have taken the position that a prompt that is a text prompt that is used to generate an image is simply an idea. And so when you do that, all the expression for that idea comes from the machine, right? So if you put in white elephant on sandy beach with palm trees and a blue tutu, the color of blue, the type of elephant, the shape of the ears, how long the trunk is, what the trees look like, where they're placed, all of those decisions, all those creative decisions have been made by the computer. So we agree with the Copyright Office that if that's all you do, then there probably isn't any protection under copyright, because there's no human expression other than giving an idea. But in our, you know, where we see it, we agree with Dawn. In fact, Shantanu Narayan, who is our CEO, says often, this is Adobe Firefly is a creative co-pilot for you. It is to give you iterative ideas for you then to take and refine in different products and things. You might change the shape of the elephant. You might move the elephant. You might change the shape of the tutu. You might take the tutu off the elephant. And all of those decisions and things that you make are human expression that would be copyrightable and would be protected under copyright. And so at least at these nascent stages, that's where we see it. As far as the output, I have to say I disagree with the plaintiffs in the Stability AI and Midjourney case that this is some sort of collage tool. If you talk to all the technologists, they tell you that all the algorithm is doing is applying weights to facts. What does a boat look like? You know, is it have a stern? Does it have a bow? How big is a boat? What's a fishing boat as compared to a cruiser as opposed to a cruise ship? And it learns these things. And when you text prompt, it generates a wholly different image. It's not taking an image that's stored in some database and supplying it. Now, there is a chance that you could have a prompt where you create something that is an infringement because you describe perfectly. You're looking at a picture, you describe it, right? Exactly. And the computer generates it. Well, in my mind, that's no more of an infringement as if I'm giving a class, an art class, and I'm told to draw a boat, and I go and I copy a boat out of a book, right? A picture of a book. I sketch it out of the book. I make a copy. It's not an original thing based on my understanding of what a boat in the water in a marina looks like. It's actually a copy. And I think our law will be applied to that. And I think, you know, could it be a fair use? Well, if what I was trying to do is demonstrate something for educational purposes or writing an article about AI, and I did that exercise and I created an infringing work, I think that that's an exception to fair use. If what I was going to do was sell t-shirts or prints of the art and it is a copy of somebody else's art, that's an infringement. So I think the law is there to protect on output, but I don't think the mere fact that output was generated from things that learned from a huge amount of data, and that of the 750 billion images, one of them might have been similar to this, is an infringement. I just don't think that. I think you have to look at the similarities between the output and the original image, and you have to have facts that show that there was some kind of access by the user of the database, and that, what prompt did you use? And those kinds of questions will come up. So I do think that there are some instances where output will be infringing, but I don't think it's a fait accompli that the mere fact that generative AI was used, it's automatically an infringement of any input that went into the database.
Yeah, so really tricky copyright issues primarily. So I thought we would turn to some adjacent to IP issues. I think we mentioned some of them, confidentiality and others, but how about the right of publicity? We're, of course, in the entertainment business, so talent issues and what has been called NIL, name, image, and likeness issues, are super important for celebrities and other famous people. But unlike copyright, trademark, and patent law, right of publicity law is not baked into federal statutes. It's usually based on state laws, and of course, there are different laws around the world. These state laws generally protect against commercial uses of someone's name, image, and likeness without their authorization, as opposed to, for example, the fact that we can name people in reporting the news or show their photograph in reporting the news. Those sorts of uses are not disallowed under right of publicity laws. So Randy, I thought I would turn to you because there are some interesting generative AI tools out there that are manipulating people's videos, and sometimes it's authorized and sometimes it's not authorized.
Yeah.
What sort of things do you think about when it comes to videos replicating faces, voices, and likenesses of famous people, and how much talent approval do you think is needed, and how is it used in sort of dubbing tools? And then I can imagine future uses like bringing celebrities back from the dead, or let's get the band back together, or things like that. And there could be a number of new uses, but what sort of things do you think about in this space?
Sure. Look, AI is exciting from, that perspective. And I understand why our, business is excited about this and what the uses could be in this realm. But, resources are down and, limited, and people want quicker, faster, cheaper methods of producing content, getting it out there for distribution. So, sound-alikes, people are looking into that, especially when they're looking to distribute content internationally. And if to language a piece of content using AI is going to be quicker and, cheaper than having to bring back the talent and do a recording in a studio and do it in multiple languages, or hiring various talent to do that. So, it's hard, but this is still evolving. And, talent, I think Tom Cruise recently is trying to copyright his likeness. So I see more talent trying to protect as much as they can, and it's going to depend on our talent agreements. So it's really for us to understand, sometimes talent has the right to do the voiceover if you're doing it in a specific language. They get the first right at it. Sometimes it will say you can't, use my voice for certain purposes, only, commercial purposes like we were talking about, but maybe for promotion and marketing you can. So for us, it's really to understand what our talent agreements say, what we can do. Do we even have the right to use AI and make a similar sound or voice or likeness? And what is the probability that talent may come after us and saying you're, not authorized to do that, or misappropriated my voice? So, I think it's a lot of understanding what we can and can't do with the talent, and, hope that nobody gets ahead of us, like you were saying, and does, a deep fake or picks up our content out there and uses it for improper purposes. And how do we handle that? And are we going to be able to quickly take it down and will the normal DMCA type options apply here? So it's going to be interesting to see how this plays out. But again, I can see from a creative perspective why our people are going to want to start doing this. And I think Dawn had raised this at one point, when we were speaking prior, that, really understanding what our our producers and production companies doing? And if they're doing it, do we know they're doing it? And make sure we're knowing we're doing it. And so we know how to distribute the content. So
You mentioned the DMCA, and I think one interesting thing is that, first of all, the DMCA, of course, only covers copyrighted works, right, not
Correct.
private publicity, right?
Right.
So that's one issue. And there was actually a viral song that was supposedly with a voice like a similar voice to Weekend and the Drake collab, but it actually was generated by AI. And when you think of that, neither Weekend nor Drake nor any of their record companies owned, right, the copyright that song, so they weren't even able to issue a DMCA related takedown for that reason. But there was some other quirky tag or meta tag within the song that somehow enabled them to do that. But it does raise some interesting issues because some of this AI generated stuff is not actually owned by people who care about the stuff getting out there. Dawn, I wondered if you wanted to spend a little time also kind of thinking about this issue and sharing your thoughts, especially when you think about deepfakes and how that could affect not only the right of publicity rights of talent, but also the reputation, right, and publicity of and brand of your company or the program or the network.
Yeah, I mean, deep fakes is going to be sort of, I could see in the future having an entire sub department in the legal department just dedicated to that, right? Because that would affect not only and damage our IP and our the value of our assets, but also our relationships. And a lot of times these are going to be things where the talent is being deep faked and they're going to come to us to say, can you help us get this taken down? And we're going to have to decide, you know, is that something that also affects us and our IP? And is it something we're going to want to dedicate our resources to? Or is this really a, you know, you as an individual piece of talent issue? But I do think the publicity, the right of publicity piece is interesting because it is outside the bounds of the contractual rights, right? So in other words, if our contracts are silent, for example, on what we can and can't do, if there's not a affirmative right for us to do something in the contract, but it's not prohibited, it might still be prohibited from the right of publicity angle, right? So all of that's going to have to be, I think, taken into account, not just going forward in our contracts about the flexibility that we are able to get from our talent, and they're willing to give us, but also with respect to the guilds, because most of at least what AMC makes is under the union contracts, right? And as we know, this is a big issue right now on the table for the SAG-AFTRA, this voice, negotiations, as well as WGA. So it's all fascinating. It's all moving at the speed of light. It's all very much important to us on all sides, right? For all these issues that we're talking about. And as Randi said, I think one of the things really driving it forward is the need for efficiencies and cost savings in the entertainment industry right now. There's a tremendous amount of pressure on us with respect to being able to make content quicker and cheaper, right? I mean, we've all read the articles about the streaming services. So you've got that on the one side, and then of course maintaining our very important relationships with all talent, whether that's writers, directors, actors, you know, all the way down the line. That is what this business is built on. So we're going to have to try to find a way to come to terms so that we can all move forward together, because to your point, Meeka, if we don't, right, people are just going to kind of from outside, the disruptors from outside the industry are just going to come and use the technology and kind of, you know, run past us, which is really not an option.
Yes, thank you. So I thought we'd close this out by talking more generally about the notion of responsible AI. We're all at this nascent stage, and just to Dawn and Randi and G. Scott's points earlier, we all have a role, you know, in how AI might shape out for the entertainment industry and other industries. So I thought, G. Scott, I would turn to you. I know you've been doing a fair amount of work on behalf of Adobe in the responsible AI space. I think that's a category, but it's a industry initiatives, and there's a big push by the public and by Congress to weed out bias in AI and to make sure that AI is being used responsibly for everyone. So I thought, J. Scott, you would have some interesting things to add.
Sure. I think first I would say is, access to data is very important. So one of the things we have to do is try to address some of the concerns that artists might have with regards to this. And we're going to be testifying today in front of Congress about this. And there's already been a story on it in Axios today, where we're proposing that we look into giving artists a right against impersonation. And it's similar to a federal right against impersonation, specific to AI. And it's when AI is being used to impersonate the artist's work, because what we're trying to do is address an economic harm. And so that's one of the things that we looked at. Because we think we can handle their economic concerns, access to data, that's a balance that we can put out there. Secondly, we believe, and we're promoting, that all generative AI should be tagged with a tag that is immutable to the work that states that it has been created or contains generative AI. And we are doing that in our products. Our products, if you generate something with AI, it'll be tagged. This was generated with Firefly, so it's generated with AI. But on the development side, we developed principles that we use of accountability, responsibility, and transparency. And the accountability is we own the outcome of the AI that we create and its effect on the market and the world. Responsibility is that we design and maintain our technology with a thoughtful and careful consideration of the impact of its deployment. And third is transparency, is we're open and we explain to our customers, excuse me, so they have a clear understanding where AI is in our products and how it's used. And we created a AI ethics committee that is diverse in both its representation of ethnicity, in gender, and to help us make sure that these principles are socialized throughout the entire organization and in every product development process. Then we also created an AI ethics board that reviews. So we built into the review of all products an AI ethics board review of the product and how the AI is used, and if there is any sort of problems with it. I think during our prep, I explained to you that at one point we were developing a feature and it turned out that one ethnicity's hairstyle was not being recognized. It was being cropped out and changed. And that was brought to the engineering staff as a problem, a big problem, before we could go general release with this particular product. And that was fixed due to that. Also, another thing, we had an editing software. Whenever you edited a face, it would remove tattoos, which was brought from the AI review board, said we can't remove tattoos spontaneously because those have religious and social implications for the models, and taking that off is very bad, so we went and refined and tried to work on that to make sure that those things didn't just happen spontaneously with the software taking those actions. So those are the kinds of things that we're doing. We're also working with a group. We started 4 years ago the Content Authenticity Initiative, and it has about 1,500 members now. Microsoft, Sony, both equipment manufacturers, software developers, Reuters, large news organizations, the New York Times, are all involved in this. And it's a way to create content credentials that would be immutably attached to an image, and that you would be able to, by choice, identify what you wanted to add into this. And we developed a standards organization, and we developed an open source standard that we want, it's not charged for, that everyone can adopt, that would allow these credentials to be seen. So if you see an image you would be able to go in and see, is it created with AI? And if the author so chose to do, they could tell you what actions they took with the AI. And this also has a benefit for artists because you would be able to show where your human creativity came in. That's your proof of your human creativity, is these content credentials that you would show. So it's thinking about those types of things. I think it's listening to one another, both the content creatives and the technology innovators, that we listen to one another, we hear one another, we try to come to compromises so that we can, allow the United States and our industries to continue to innovate in these areas. Our general counsel likes to say it's balancing innovation with responsible innovation.
I love that. So Randi, I thought I would get your thoughts. Legal is sometimes a place where issues around bias and being a responsible company lands, at least at some level. So I thought I would just find out your thoughts from a network point of view. What kind of things you think about?
I think, we have to start thinking about, how do we disclose if we are using this? Where's the appropriate place and time in a piece of content? And how do we think consumers are going to react? Sometimes there's a negative implication with using AI for certain things. And, also as we're negotiating with vendors and different third parties, if they are using it, to be careful that whatever they're doing doesn't implicate our brand reputation, and how do we protect, for that. And so things just to consider and think about as this is evolving. I don't have all the answers. I wish I did, but these are just the thoughts that have started to come to mind as this, because we don't know what we don't know yet.
Exactly, and this is exactly why there was this summit, because we're just starting to think about all these issues, and it's great to have a discussion. And I want to thank all of you for participating. So I thought I'd close out by asking each of you to just name one item, a word, or think about what are you most excited about when you think about generative AI, and then what are you most afraid of when you think about generative AI. We are lawyers after all, so we do worry about the bad things. So maybe I'll start with you, Jason. What are you most excited about, and what are you most?
The expansion of creativity is what I'm most excited about, to all kinds of people, right? And what I'm most worried about is forging innovation and unsettled law. Keeps me up at night. Did we make the right choices? Have we done the right risk assessment?
Very good. How about you, Don?
As a musician, I probably should also say what Jay Scott said and most excited about the creative potential. But putting my lawyer hat on, I'm actually going to say I'm most excited about the efficiencies and the cost savings that I think we're going to see in our industry and others. And I'm most afraid of AI being able to replace me and my job.
It's a fair amount of evidence that a lot of legal functions will be replaced by AI. Some of them I won't want. Yeah. How about you, Randi?
I would say similar to Dawn, quicker processes and efficiencies, get rid of some of the mundane stuff and hopefully can generate quicker. And then most afraid of, I would say, is criminal acts with deep fakes. That really freaks me out, to be honest. So we're starting to see some of it.
Yes, definitely.
Yeah.
I'll close out with I'm most excited about innovation. I find all kinds of emerging technologies that lead to advancement super interesting. I am most afraid that people will be left behind in the workplace on various levels. I guess that's the piece but maybe we should end on a happy note. We're closing out this generative AI session. I hope all of you enjoyed our panelists today, and thank you, Dawn, thank you, Randi, thank you, Jay Scott, for sharing your views and your expertise. Obviously, this conversation